Welcome to Washington in Focus. I'm your host, TJ Martinell, and with me is Carlene Johnson, and we're going to be discussing a story of hers that was published recently. Last year, Initiative 2066 was passed by voters to protect natural gas, and it has been struck down by a King County Superior Court judge and is expected to be appealed all the way to the state Supreme Court. So, Carlene, tell me a little bit about the initiative itself. What exactly did it do?
Yeah, the motivation for 2066 was to make sure that as Puget Sound Energy, the state's largest utility, moved toward cleaner standards to meet, climate commitment goals set by former Governor Inslee, that in doing so, they weren't phasing out natural gas, because right now the Washington State Building Code Council is, has regulations that move in that direction for new construction, for ongoing maintenance. Say you've got a natural gas powered water heater like I do in your home, and I need some parts for that. Building Code Council is now disincentivizing the repairs with current parts, because they want to move toward more efficiency when it comes to fossil fuels like natural gas. So that was the motivation for 2066 to say, hold up, Building Code Council, we're not going in that direction. We can work on climate commitment goals, but it's not going to be, at the expense of natural gas being phased out. So that's what voters approved in November. And 2066 has still not been implemented by the Building Code Council. And that was the motivation for the fun little activity in King County Superior Court that played out last Friday.
Right. So tell me, what was the judge's, actually, let's talk about the plaintiffs. What was their argument?
Yeah. So their argument was that 2066, basically is in contradiction with the goals, the clean climate goals that have been set, and that we need to keep moving in that direction. And the phasing out of natural gas over time, they say, is something that they want Puget Sound Energy to continue to do. So you had King County and Seattle and other conservative, conservation-minded energy groups that got behind this, all lumped under Pacifica Legal Group. And this is a liberal organization that often is supportive of left-leaning organizations and goals. So they took this thing to court, and in the courtroom of King County Superior Court Judge Sandra Widlan last Friday, an Inslee appointee, as former Governor Inslee, sat right behind me in the courtroom.
I was about to ask. He was literally in the courtroom. Yeah.
Well,
one of his appointees was making ruling on this.
Right. And I didn't see him when he first walked in. I was actually seated next to a couple other members of the media that were there. And then I heard kind of some rumblings and turned around, and former Governor Inslee was seated in the row right behind me, kind of smiled and nodded. And I don't know if he remembered me or not, but then he was kind of making some nods at the judge. He appointed her in 2018. And that is one of the issues that might be raised at the state Supreme Court, as this thing is proponents of 2066 have asked for direct appeal to the state Supreme Court. And that's one of the issues. They're going to say, wait a minute, maybe this judge should have recused herself because she was an Inslee appointee. She's a big donor to like Dow Constantine, Bob Ferguson, Inslee, all these, more left-leaning, progressive, if you will, candidates. Dozens of donations over the last several years she's made to those campaigns. So should she have recused herself? Maybe ethically so. It doesn't sound like even...
It almost begs the question of whether or not she donated to the campaign against the initiative.
Well, that's a good question. I didn't see. Yeah.
I mean, that would be, I don't know if that's public disclosure, public record. Maybe it is, but that might be a follow-up stories to see.
I was going to say, that's your beat. You're the public records guy. Go find out for us. But well, those candidates that she was donating to openly, opposed 2066 before it went to the voters last November. Dow Constantine and others. well, there were several Seattle City Council candidates. And remember, Seattle's one of the plaintiffs in this case, that she donated directly to those campaigns. So if perhaps nothing under, political rules about contributions for candidates was violated here, but ethically, the appearance of fairness probably called into question. And I expect that to be one of the issues that's raised when this thing, assuming it goes direct to the state Supreme Court, which is what, supporters of the initiative are asking for.
I'm noting one of the arguments is by the plaintiffs was that the ballot measure's title may have confused voters. The titles are written by all initiative titles are written by the Attorney General's office. And so theoretically, the Attorney General's office could kill any initiative it wants that it doesn't like just by writing a title that is unconstitutional.
That's a good point.
It really just raises the question of how, if an initiative can be struck down through the ballot title alone, and the Attorney General's office gets to write the titles, then it kind of undermines the whole concept of an initiative process, because the Attorney General has final say. They can just say, yeah, we don't like this bill title, and we're not going to come out and say it, but we're going to make sure that it's, because this is not the first time an initiative has been overturned. There was, I can't remember, it was the $30.
Yeah, it was one of Iman's. Yeah, it was one of Iman's initiatives.
And it was also found to be violating the single subject requirement, which is funny because there's been other laws that have raised taxes that have been challenged on the same grounds, but they have been upheld. So, yeah, and
that was one of the big arguments. And an attorney from the, now Attorney General Nick Brown's office was there to argue in defense of the initiative and mounted what seemed to be a pretty good argument. It didn't seem like he was giving a wishy-washy defense argument. And then as well, there was the Building Industry Association of Washington had an assigned attorney to the case there that made those arguments as well. But you're right, that was the argument about the single subject rule, the title being confusing. And they kept saying that over and over again, that voters didn't really understand that when they were voting to retain natural gas as an energy choice, that it would also lead to these other things like potentially slowing down reaching climate commitment goals, or that it would force the State Building Code Council to revise some code. They basically said voters didn't get it.
Well, I mean, that kind of reminds me of when ST3 was passed in 2016, and then the same people, the voters who approved it, started getting their vehicle tab renewal
skyrocketing,
and we're freaking out. And so one could argue, I mean, if they're going to make the argument that something should be overturned because it confuses voters, how many things have voters approved over the years? Or we could argue the same thing for elected officials. Oh, they were confused. They thought this candidate was in favor of this, but then the candidate was actually not in favor of that. So it's hard to prove that voters were confused, because that's all. That's just speculation. You'd have to do a survey, and then it just raises the questions of, define confused.
Well, and you're right, because, and there's voters that are just very casual about it. The day they're filling out their ballot, they're like, 2066, what was this one again? There's been so many initiatives, I can't remember. And they might do a quick Google search. And of course, you can find the information there. You got the video voters guide, you get your voters pamphlet that comes in the mail. I mean, and even in the brief description of 2066 on the actual ballot, it talked about some of the things that it would do as far as amending Building Code Council regulations. So that was there. I don't necessarily buy that argument that voters were confused. I think that, maybe people that are supporters of the climate commitment goals and maybe voted for the CCA and everything else didn't realize that, this would perhaps have some impact on the environment if they keep natural gas. I don't know. I give the voters a little more credit than that.
What's interesting also is one can make the exact opposite argument about the other three initiatives that voters did not approve. One could argue that those ballot language, the title language, was confusing.
Right.
And that's why they voted overwhelmingly, or not overwhelmingly, they voted in favor of the natural gas initiative, not the other three. I mean, proponents of the initiatives can make that argument that the ballot title language was confusing and people voted against stuff that they otherwise would have supported and voted in favor of something. So and if the ballot language is confusing, it really raises the question of who should be writing the ballot title language. You know, if we keep running into this thing where initiative after initiative is being sued on the grounds that the ballot title language is confusing, that really calls into question the capacity for the Attorney General's office to do this. So it would be interesting to see how many initiatives have had this happen.
I think you're right. And as you well know, the majority Democrats in Olympia have been trying to get at undermining, I guess, the initiative process in any and every way they can. But right in the state constitution, I mean, you know, this is such an important, you know, constitutional right that Washingtonians have. And it's one of the only ways that, you know, minority Republicans in this state have of kind of getting back and undoing some of, you know, these bills and huge tax increases that, like with the CCA, people could say, well, I love the environment, so I voted for that. I didn't know my gas prices were going up 50 cents overnight. I mean, it's a way that people have an opportunity to weigh in after the fact with these other bills that they otherwise don't have any say in. So,
yeah, you know the irony of this is that the state right now currently has a program through the Department of Ecology where they will provide subsidies for homeowners to switch from a wood-burning stove to natural gas. So currently our state spends millions of dollars. I
still hear those ads. Yeah.
So it's just ironic that I understand what they're trying to do. These are for homes that rely solely on wood-burning stoves to heat their homes. And they're saying, hey, switch over to natural gas. It's better for the environment. It puts less pollution into the air. But it's just ironic that they're spending money to switch people to natural gas while they're fighting to have it banned for, you know, future homes or restricted in some way.
And now we wait to find out if, in fact, the state Supreme Court will take the request for direct appeal. Very likely, according to folks that I've spoken to at the National Natural Gas Association, they believe this fight in Washington is right now the biggest in the nation as far as the protection of natural gas goes. They were, you know, big supporters of 2066. So now with this thing being overturned, ruled unconstitutional in King County, assuming the state Supreme Court goes along that same vein, which one could guess that's probably going to happen. And maybe if it goes straight to Supreme Court from there, U.S. Supreme Court, or perhaps Ninth Circuit Court, probably a rubber stamp of what King County or the state would do. It's likely to end up at the U.S. Supreme Court from what I'm hearing. But of course, this is going to take years to play out.
Well, in the meantime, listeners can keep up with this episode and more of our work at thecentersquare.com. I'm your host, TJ Martinell, and thanks for listening.